Is liberty dying where you live? Escape to Keene at freekeene.com.
Sorry for the delay.
Kilham's the only one who stood up.
All right, this is on Derrick J, Keene Police Department. And we didn't take any substantive testimony yet, correct?
Correct.
And what's your best estimate on time here, Counsel?
Oh, morning, Your Honor.
Morning.
Probably, Your Honor has ruled that this would be viewed after the hearing, so that being the case, as far as our side, probably maximum, imagine over half an hour.
Okay, because we have other cases left over, so
Yeah.
give them an idea of how long to wait. All right, ready to proceed?
Yes, Your Honor, the state calls to control Chittister. Please remain standing, raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth or that it means a penalty of perjury?
I do.
Okay, if you please have a seat. You can state your full name and spell your last correct.
I'm Detective Chittister. His last name is spelled C-H-I-D-E-S-T-E-R.
And how are you employed?
By the Keene Police Department.
As a police officer?
That's correct.
And for how long have you been so employed?
I've been a police officer since 2010, with the Keene Police Department since 2015.
And are you a certified law enforcement officer in New Hampshire?
I am.
And what is your current assignment at the Keene Police Department?
I'm assigned to the Bureau of Investigations as a detective.
And as one of your duties as a Keene Police Department detective, to review the permit applications submitted by Keene residents.
It is.
And do you conduct background investigations concerning each application?
Yes.
And what is the process that you follow when you conduct these investigations?
I review the application for completeness and I conduct a criminal record check on the applicant.
Okay, and what does that record check involve?
The record check is standardized for any sort of criminal applicant or just a permit application, and it would involve any sort of arrests or convictions for criminal offenses in the United States of America.
What do you do once you complete your investigation?
Once it's complete, if there's some sort of criminal record found that may prove to be of impact to that particular application, it would be forwarded to the Chief of Police for review and his approval or denial.
And drawing your attention to July 2nd of this year, 2014, did you review a pistol permit application submitted by Derrick J?
I reviewed one early in July of this year, yes.
Okay. I'm going to show you that application.
There's no objection.
State Master Marcus, State 601. Mr. Who and Ms. State 601, is that the pistol permit application submitted by Derrick J in July of this year?
It is.
Okay. And what were the reasons he was seeking the application?
Per the application here, he applied for self-defense and all lawful purposes.
And
all lawful purposes.
Are there a series of questions that the applicant has to answer on the application?
Yes.
And does one of those questions concern the use of controlled drugs?
It does.
And what specifically does that question read?
Are you an unlawful user of or addicted to any controlled substance? And there's a yes or no answer.
And how does he answer?
No, it's checked.
Did you run a criminal record check for Mr. Horton?
I did.
And you reviewed that, I think?
I did.
right?
Just removing this United States Exhibit 2, is that Mr. Wharton's criminal record?
Yes, there would be some.
And that's the specific criminal record you reviewed when you were conducting a background investigation concerning his application.
That is correct.
And can you summarize or go through page by page and tell the court what specific convictions he has on his record, the conviction date, the court record, the offense, and the sentence, if you will?
Yes. Starting at the first page here, there is a court date of the, looks like the 18th of January 2012 here in the Keene District Court.
For the record, I'm going to object to this as hearsay. For the record, I understand Your Honor's ruling, but I would make that objection strictly for the record.
No.
Thank you, Your Honor.
And that's ongoing with all.
Ongoing, that way I don't have to keep saying up and doing that.
I understand.
Thank you, Judge. Thank you.
And just for the court's information, Attorney Nappen didn't respond or object to the state's motion when they concerning this testimony. So I just wanted to
Well, I understand, but it was raised in an earlier proceeding, and you know, if he wants to appeal on that basis, then that's preserved.
That's precisely my reason. Thank you.
check it too, sir, if you will.
It appears that on the 18th of January 2012 here in the Keene District Court, there was an offense charge as obstructing government administration, a Class A misdemeanor, plea of not guilty and finding of guilty. It appears on the, it's like the 1st of May 2012 here in the Keene District Court.
Does that reflect the level of offense?
Oh, I'm sorry, if you could also identify the level.
Oh, that was a Class A misdemeanor, the first one I read for obstructing government administration. It appears that on the 1st of May 2012 here in the Keene District Court, there was a charge alleging possession of controlled drugs. It's a Class A misdemeanor, plea of nolo, finding of guilty. It appears that there was on the 21st of November 2011 here at the Keene District Court disorderly conduct that was no prost. There appeared to be in the Laconia District Court on the 18th of January 2012 resisting arrest charge as a Class A misdemeanor, plea of not guilty, finding of guilty on appeal.
When you say found him guilty on appeal, does that mean it was appealed, or is it found guilty on appeal?
He appealed it and he was found guilty.
That's what that means?
Yeah.
I didn't know if it meant it was still on appeal.
That's my understanding.
Okay.
It appears that on the 18th of January 2012 here at the Keene District Court, there was a Class A misdemeanor for resisting arrest that was dismissed.
What's the date on that?
The 18th of January 2012.
And maybe I wrote something down wrong. I have January 18th, 2012, a Keene District Court disposition. And I had January 18th, 2012, a Laconia Court disposition the same day.
That is how it's reflected in the criminal history. There appears to be another charge on the 1st of May 2012 here at the Keene District Court for a criminal trespass. That was no prost. There is a criminal contempt. 2nd of May 2012 here at the Keene District Court, that was no prost. There was a resisting arrest charge here at the Keene District Court on the 1st of May 2012 as a Class A misdemeanor that was pled as nolo, finding of guilty. There is appears to be possibly an appeal to the Cheshire Superior Court on the 1st of May 2012 for obstructing government administration, misdemeanor Class A, finding of remanded. There is Same date and same court, Judge of Superior Court. Offense alleging resisting arrest or detention is a misdemeanor A, again remanded from Superior Court. There is a record on the 1st of May 2012 in Keene District Court for criminal trespassing as a violation. That was pled nolo, finding of guilty. There is...
Excuse me, because I'm going to watch the... Do I have the audio here, the DVD here?
I have it here, Your Honor.
Because I'm going to be watching that after I take it under advisement.
Okay.
I'm also confused on whether these are repeating the same offenses on appeal, remand. I'm going to need the state to set forth exactly where this all shakes out, as far as the record is concerned, share it with counsel, see if they have any disagreement with it, because I've got, there may be you cited 3 different offenses that may actually be the same offense, and I can't quite follow it.
And what I think I'll do, actually, I'm going to ask the to stop talking about the record. I do have, at least as far as this court's concerned, a certified copy of the convictions.
I'm taking these notes here, but I can't, it sounds like I'm hearing the same offenses.
I understand, and I think that will probably be the cleaner way to do it, but this criminal record reflects a Laconian circuit court conviction that's not here, so.
Okay.
I think
I just wanted to...
And these are self-authenticating, so they should come in as an exhibit. I've asked this to enter these as exhibit 3. Turning out the other body.
So if there's a conviction here, it's appealed and remanded, that'll be reflected in there?
Yes.
Okay.
Judge, the records that are the actual court records, that these are copies of, and I'm assuming there'll be foundation laid for that. I would not object to, but in front of this is there is a case summary, and that is a computer-generated hearsay, if you will, allegedly reflecting other records. So to that portion, just for the record, I would object to that portion of the documents.
And I would argue under Rule 902 that these are self-authenticated, these are court-certified convictions. One, there was a case summary provided rather than the actual complaints, but all the other convictions are...
My understanding is the objection is not to the actual conviction, the complaints that are reflected in there, but to a recap or summary. The second page is a summary page, and that doesn't prove anything one way or the other. That's what you're saying?
That's correct.
And that's not true. It specifically lists the entire procedural posture, of the case from start to finish.
Well, let me see.
Conclusion, and I would also say it's important to take judicial notice of it.
Well, that's the other thing. I mean, I can take judicial notice of the records of the court anyway, but you have to refer me to... I probably wouldn't be looking at those pages anyway, but I'll accept it with that proviso.
Okay, thank you.
So this be stage 3?
Yes, please. I'm just going to leave this here for a moment because I'm going to ask you to refer to it in a few moments. As part of the investigation concerning his report, this pistol point application, did you review Keene Police Department reports concerning an arrest of Mr. Horton on September 9th of 2011 for the offenses of obstructing government administration and resisting arrest?
I did.
Just for the record, my objection, as hearsay.
Okay.
Thank you.
State will ask the court to do this as
Petition is...
Thank you.
Concerning Mr. Horton's arrest on September 9th, 2011. Can you summarize the facts of Mr. Horton's arrest for those offenses?
This is a police report written by Keene Police Officer Michael Koptra. From his report, he alleges that on the 9th of September 2011, around 10:30 in the evening, the 9th of September 2011, 10:30 in the evening, he and other officers responded to the Central Square here in Keene for a noise complaint. They found a group of people there with some audio equipment set up. They had determined that there were no permits issued to these individuals for the gathering or for the electricity provided by the city there. They had asked who owned this electronic equipment and the audio equipment. That person subsequently came forward. He was receiving a summons for the noise violation, and the audio equipment was going to be used as evidence in that case. Therefore, Police Officer Koptra went up to take control of this audio equipment and encountered then an unidentified male later found to be Mr. Horton. Reading from his report, this subject was picking up cables and gathering up his audio equipment. Koptra informed this person that the audio equipment was being seized as evidence, at which point this person replied that no, the officer was not going to take this equipment, and attempted to pick up some of it and hold on to it. Officer Koptra attempted to retain this evidence, during which some sort of scuffle ensued. Officer Koptra then tried to take this person into custody. They ended up on the ground. They were still holding on to the evidence. Officer Koptra ordered Mr. Horton to release the evidence, which was ignored. He then attempted to place him in handcuffs and had some difficulty in doing so. Once he was in handcuffs and being escorted to a cruiser, he refused to sit in the cruiser. Officer Koptra had subdued him with some OC spray and to take a seat in the cruiser to be transported. Subsequently, at the police department, this male, again now known as Mr. Horton, refused to identify himself or cooperate with the booking process.
Thank you. I'm going to show you now. This is Exhibit 3. These are the certified convictions in this court, and this particularly concerns the case summary. Can you tell the court whether he was convicted of those offenses?
It would appear on the 18th of January 2012 that he was found guilty on the obstructing government administration charge and sentenced to fines, and it looks like a term of time at the House of Corrections that was suspended. The resisting arrest charge he was also found guilty on, again fines, and suspended House of Corrections time. And it looks like there was a third resisting arrest charge that was dismissed, and a town ordinance charge that was placed on file.
And are those convictions also consistent with what is reported in his criminal record in State's Exhibit 2, as I understand?
Yes, my understanding that's correct.
And did you also review an arrest report for an arrest made by Keene Police Department officers of Mr. Horton for the offenses of contempt and possession of a controlled drug for an incident that occurred on September 14th of 2011?
I did.
I did show Attorney Nappen this morning. And that was State's Exhibit 5.
And just for the record.
Same objection?
Same.
Mr. Review is State's Exhibit 5. Is that the report that you reviewed concerning his arrest on September 14th of 2011 for the offenses of common law criminal contempt and possessing a controlled weapon?
That is correct.
And can you please summarize the facts surrounding that arrest for the court?
There are numerous reports of intent laws involved. The main one being one written by Sergeant Jason Short of the Keene Police Department, who alleges that on the 14th of September 2011, he was part of a group of officers that responded up to Central Square in Keene due to a group of people there who were believed to be conducting a protest. At around 16:15 hours, he observed the subject who he knew to be Derrick J. Reading from his report, it says that he arrived at the square. The subject walked over towards the vicinity of the fountain at the square. Sergeant Short believed that Mr. Horton was going to attempt to smoke marijuana there at the square as part of the protest. He saw him removing items from a backpack or a bag that he had with him. He spoke to Mr. Horton. Sergeant Short advised Mr. Horton that if he was planning to smoke a controlled drug, that he would advise against that. Apparently, Mr. Horton made a comment to Sergeant Short that, in quotes, "I really want to smoke this weed." At approximately 16:30 hours, Mr. Horton had a lighter. He took this pipe, appeared to be preparing the contents. As he raised the pipe up to his mouth, Sergeant Short could see that it contained a green leafy substance, which he believed to be marijuana. He seized this pipe as evidence, and through his training and experience, he recognized the contents to be marijuana, and he subsequently field tested positive for the presence of THC as a presumptive test. Mr. Horton was then placed under arrest and taken back to the Keene Police Department.
Again, refer you to State's Exhibit 3 rather, concerning the defendant's convictions for these offenses. If you could just take a look at the documents to confirm whether he was convicted of possessing controlled drugs, specifically marijuana and common law criminal contempt, for the offenses that you just described in the court.
There's a complaint here alleging on the 14th day of September 2011, Sergeant Short filed for Mr. Horton knowingly possessing a controlled drug, to wit marijuana, in a Class A misdemeanor. Looks like a plea of not guilty, and then it looks like that was changed to a plea of nolo and a finding of guilty, and there was a sentence accordingly.
And what was the date of the conviction?
Looks like the 1st of May 2012 in the Keene District Court.
And that's for both offenses he was convicted of on that date?
Looks like the second complaint's for common law criminal contempt. And looks like a similar circumstance in the Keene District Court, finding of guilty on the 1st of May 2012.
And if you could flip to the next page, do those certified convictions show that he was convicted for criminal offenses of common law criminal contempt and criminal trespass for arrests made by the Cheshire County Sheriff's Department or about February 22nd of 2012?
There's one here on the 27th of February 2012 by Lieutenant Michael Garecki of the Cheshire County Sheriff's Department for resisting arrest or detention.
And what does that complaint read?
The complaint reads to knowingly physically interfere with a person he recognized to be a law enforcement officer, to wit Deputy Sheriff Michael Garecki of the Cheshire County Sheriff's Department, by running while said officer was seeking to arrest Mr. Horton.
And what was the result of that charge?
Similar to before, looks like a not guilty plea changed to a no-go plea with a finding of guilty, and sentenced accordingly here in the Keene District Court on the 1st of May 2012.
And is there another complaint concerning the Sheriff Department's case?
There would appear to be one, a violation of lawful criminal trespass, again on the 27th of February 2012. This is a handwritten complaint by Assistant County Attorney Mr. Warren, stating that Mr. Horton did commit the crime of criminal trespass and he knowingly entered the property of the Cheshire County Superior Court at 12 Court Street, Keene, New Hampshire, after having been served in hand a letter of no trespass on the 3rd of January 2012, said letter being issued by Sheriff Richard Foote, instead entering of the property in defiance of the criminal trespass letter.
And what was the result of that charge?
That appears to be a no-low plea with finding of guilty on the 1st of May 2012 here in the Keene District Court.
And did you also review?
What was the date again?
The 1st of May 2012.
Did you also review a report concerning a Keene Police Department arrest of Mr. Horton for an incident on March 30th of 2012 for resisting arrest and common law criminal?
I did.
Yes, noted.
After this is 666. Should we start handing you that police report, which is dates Exhibit 6, if you can summarize the facts surrounding that arrest for the court?
This is a report written by Keene Police Officer Fenton Moore that alleges that on the 30th of March 2012 at approximately 3:13 in the afternoon, Officer Moore was on patrol and saw Mr. Horton riding a bicycle, and he recalled that the Keene Police had been attempting to serve paperwork to Mr. Horton for the past several weeks. He pulled up alongside Mr. Horton and asked him to stop and that he needed to speak with him. Mr. Horton dismissed and disregarded Officer Moore and rode off, saying something to the effect that he was under no obligation to stop. Mr. Moore followed Mr. Horton with the cruiser blue lights and siren deployed, again asking Mr. Horton to stop, and he refused and continued on his way to the bicycle. This continued for some distance with a similar fact pattern there. Officer Moore was subsequently able to bring Mr. Horton's bicycle to a stop. There was some sort of tussle that had ensued thereafter. They ended up on the ground. Officer Moore was attempting to place Mr. Horton under arrest. Mr. Horton refused to comply and refused to place his hands behind his back to be handcuffed. Several other officers arrived and were able to get Mr. Horton into custody, and he was transported back to, looks like the Cheshire County House of Corrections.
If he said, and I missed it, what was it, according to the report, what was the purpose for Officer Moore seeking to detain Mr. Horton?
Apparently, the Keene Police have been attempting to serve him with a criminal trespass notice.
Prior to Exhibit 3. These are the court convictions. Can you please advise the court whether Mr. Horton was convicted of the offenses that you just
This is a criminal complaint completed by Officer Moore alleging a Class A misdemeanor for resisting arrest, which states, the complaint states that the defendant did knowingly physically interfere with a Keene Police Officer, Fenton P. Moore Jr., a person whom he recognized to be a police officer, by refusing to roll over onto his abdomen and present his hands for handcuffing as Officer Moore was attempting to arrest him. That appears to be a plea of nolo with the finding of guilty here in the Keene District Court on the 1st of May 2012.
And was that also a Class A misdemeanor?
It was.
And
It looks like accompanying that was a common law criminal contempt complaint by Officer Moore for that event as well.
And was Mr. Horton convicted accordingly?
That was brought as a Class A misdemeanor, and and it appears to be a not guilty plea changed to a plea of nolo, the finding of guilty here in the Keene District Court on the 1st of May 2012.
Thank you. So once you completed your investigation, you reviewed these police reports, Mr. Horton's criminal record, you indicated that you had sent this information along to GPL, is that right?
That is correct.
And did you, sorry, oh, thank you.
Counsel?
Thank you. Good morning. In your review of all these records, any felony convictions, Mr. Wood?
Not that I saw, no.
So, based on that, you understand that you can be legal for possession of firearms, right?
That is correct.
Now, what's before the court, you're going to get a New Hampshire license to carry, right?
Correct.
And that's what the application was for.
Yes.
The, exhibit 3.
I think they're all in front of the witness.
Right.
Yes, of course. You don't have to add this as long as you know consent.
Thank you. You testified about the charge of knowingly possess a controlled drug with marijuana that allegedly occurred on September 14th, right?
Yes.
Okay. And in that testimony, you referred to a police report as well. What report did you refer to on that?
I believe that would be State Exhibit 5.
So, in State's Exhibit 5, you reiterate that in that report, now you weren't there physically on that day.
That's right.
That in that report, it stated, who was the officer at the time who wrote that report?
Several officers wrote it. The one that I referred to in my testimony was from Sergeant Short.
But you reviewed all the reports, right?
Yes.
In all those reports, none of the officers said that Mr. Horton actually smoked marijuana, correct?
I believe that Sergeant Short's report states that he took possession of the pipe before Mr. Horton could light it.
Before he could light it. So that there was no observation by any officer in any of those reports of actual use of marijuana, correct?
Correct.
Now, he said he wanted to use it, didn't he?
Yes.
Okay. And tell me, have there ever been things in your life that you wanted to do?
Counselor, I don't mind you going
I'm
back.
sorry.
You don't need permission to go up
Oh,
on the
thank you.
exhibits, but if you...
I'll stand back here. Thank you,
I'm just
Judge.
going to ask the question.
Sure. Is there anything in your life you've ever wanted to do but you didn't do?
Is there some relevance to that?
Well, that's the evidence put forward.
I think you can argue that. I don't think it's relevant to that.
But the fact is, regardless of his desire or want, nothing in your reports said that he actually used it, right?
Correct.
As a matter of fact, the charge itself is possession, no use of marijuana, how even alleged in the complaint, correct?
That's
Strictly possession. And this possession occurred, I believe you said, at a protest, right?
Yes.
So in other words, this was a political event taking place, correct?
I don't know if it was a political event, it was a protest of some sort.
What were they protesting, you know?
I was not present, no.
Okay, so, and the reports indicate what they were protesting?
Not to my knowledge.
So if I told you they were protesting, let's say, the marijuana laws, would you agree with that?
Something relevant to that.
You can ask that question.
Thank you, Your Honor.
I think you need to know what the aspect of the protest has to do with what I have to decide on the occurred.
It goes directly to the reason for this criminal charge and the other criminal charges. It goes directly to what Mr. Horton is about. He's about being a liberty
I
activist.
said you could ask a question.
Oh, I'm sorry. I thought you wanted me to do all your proffer.
At some point, I want to just get to the point about the protest, but you can certainly ask a question.
Okay, thank you.
Can you repeat the question?
Sure. So do you think this was a protest about marijuana laws, trying to legalize marijuana?
You can speculate on that. This is not a...
That's possible.
So you would say it's a possibility?
Yes.
But you're not sure?
No.
And the reports don't tell you then, do they? Because you know that, right? The reports don't say what was going on.
The courts do not specifically state what the protest was about. They make reference to marijuana use.
So your knowledge is limited strictly to what you read in those reports, right?
That's correct.
You didn't further your investigation by talking to any of the officers or anyone involved in these arrests?
That's what we said, sure.
And you never asked them what the protest was about?
No, nothing further than what you wrote report on.
So the complaints of convictions that you reviewed in, I believe it's State's Exhibit 3, did you further inquire as to whether any of these may have been reversed on appeal?
Only what is reflected in the record there.
So you're not, are you aware of any of these being reversed on appeal?
I read some in the first section that were dismissed or no cross. I don't know which ones.
Detective Chester specifically testified he changed his pleas to either no or guilty, so I think there is no appeal if you plead to the charge. I think that's reflected clearly in the documents.
I guess you can ask, and he already has asked, if he's aware if anything's been appealed. If they have evidence that they were appealed, they can offer it.
So you're not aware of anything being appealed, you don't know?
Some of the ones I read in the first record were listed as remanded from Superior Court, so I assume that there was an appeal on them at some point in time.
Now,
I guess if you're asking for appeal, you're talking about appeals from this court or Supreme Court appeal.
well, that's fair. In terms of appeals, do you know what court these matters were appealed to?
I believe Superior Court, since that was the only court that was referenced other than district courts in this record that I referenced earlier.
You aware of any appeals to Supreme Court?
Not that I'm aware of.
They said the pleas were no-lo, right?
Yes.
You know, what does a no-lo plea mean?
It's in no contest, to put it into plain language.
So, when a plea of no-lo takes place, the person making that plea is simply not contesting the charge.
Yeah, that's correct.
He's not admitting to any facts. Right.
No, he's pleading no contest.
And so, in your consideration of these offenses, did you ever consider that on all those no-lo pleas, there was no admission by the applicant as to the facts? Did you put that in your consideration?
I consider the fact that he had these criminal convictions on his record.
And so you just looked at it in terms of, here are the convictions, and that makes him disqualified. Kind of like, it's there, it's this, it's that. Is that how you looked at it?
This witness didn't indicate what his position was. It was the chief's determination whether Mr. Horton was suitable.
Witness testimony that he takes the information and passes it on to the chief. So it's the chief's decision that's an issue here, correct?
Okay, then is it purely the chief's decision whether to issue a license or not?
Yes.
Did you make any recommendation to the chief, one way or another?
I brought these facts to the chief and suggested that he may not be a suitable person and left for the chief to decide.
So you recommended that he deny the application for not being a suitable person, right?
I didn't make any recommendation one way or the other, so that he may not be a suitable person and left it for the chief to decide.
Oh, I see. So do you say that you routinely process these applications for anyone in the town? Right?
Correct.
And when you hand the packet up to the chief, on each application you say, hey, he may not be a suitable person. You do that for each applicant all the time? This person may not be?
No, I'll call the chief's attention to certain facts that my investigation may have uncovered.
So who would be the applicants that you might just suggest to the chief may not be a suitable person? Who would those people be that you would suggest like that? Who would that be? That you would suggest to the chief he may not be a suitable person?
I'm not saying that follows your question.
You say you don't routinely tell the chief that every applicant may not be suitable, right? There's a decision being made by this.
No decision being made by the witness according to the testimony. He made a recommendation. It's up to the chief to decide. You can ask the chief what way he accords to the recommendation that the witness offers him, but this witness doesn't make the decision. We'll try, and we'll hear.
Thank you, Your Honor. I understand the distinction. So that you merely make recommendations to the chief, right?
No, I bring facts to the chief's attention based upon my investigation.
And you don't offer any recommendation?
I think the witness's answer could be interpreted as a recommendation. It could be interpreted as not a recommendation. I'll just leave it up to me to figure out what meaning it has to this case.
Nothing further. Thank you.
Thank you. Any redirect? Thank you. Witness be excused?
Yeah. State College Township, Chief Kenneth Neola.
You want to rank these to you?
Yeah, before, he may need to refer to them. You can take a stand. If you don't mind, the people there have an agreement. I just want to take their opinion on the landlord-tenant case so they can be relieved. Folks, want to step up here?
Okay, you can state your full name and spelling last for the record.
Kenneth Neola, N-E-O-L-A.
And how you appointed?
With the City of Keene Police Department, have been for more than 25 years now, almost 5 years as police chief.
And you're a certified law enforcement in New Hampshire, correct?
I am.
And when were you so certified?
1989.
And as one of your duties as a police chief for the Keene Police Department, is it your decision to grant or deny a Keene resident's physical permit application? And you task the Detectives Bureau with the background investigations?
I do. The statute actually allows me to designate personnel, full-time officers to do that. And I do designate the Bureau of Criminal Investigations to carry out those duties.
And presently, the person who performs these background investigations is Detective Joel, correct?
He is the primary detective that does those tasks. However, there are others who are also allowed to do that in his absence.
And drawing your attention to July 9th of this year, 2014, did you have occasion to deny a pistol permit application submitted to the Keene Police Department by Derrick J?
I did.
And you denied that application?
I did.
And did you send a letter to Mr. Morton concerning that denial?
Yes, the letter which I was sent for denial.
Statement C, evidence states.
No objection to that, Your Honor.
Thank you.
Is that a copy of the letter that you sent to Mr. Horton?
Yes, it is.
And when you made that decision, what were the reasons you decided to deny the application?
When the packet was presented to me with the application and all of the background information that Detective Chittister previously testified to, I look at it, based upon the course of conduct, to see what the behaviors were, what the convictions were, and then I applied that to, and I understand that the term suitability in the statute, the license to carry RSA is somewhat vague, so we tried to use that to look at course of conduct, and what is that conduct based on? Is it based on judgment? Is it based on specific behaviors that incite or inflame situations? Or, I mean, there's a myriad of things we look at realistically to try and determine that suitability component. And as I looked at Mr. Horton's packet and his behaviors beginning in 2011 through 2012, that course of conduct of the obstructing governmental administration, possession of a controlled drug, the resisting arrest charges, in my mind, that is determined a person who's not suitable under the statute to possess a license to carry.
And specifically, because of that course of conduct that Mr. Horton exhibited, why did that cause concern as a police chief?
Correct.
Why?
Well, I think, can you repeat the question? I'm not sure I understand.
I'm sorry, sure. Based on Mr. Horton's course of conduct, why did that raise concern on your part?
I think when I looked at his course of conduct and how it pertained to judgment in situations in which he was arrested, the conscious act to go out and commit some of these crimes, albeit for whatever reason, I think really played into that decision making.
In your mind, his course of conduct is someone who is not suitable to be carrying a concealed weapon, correct? Thank you.
Albeit for whatever reason, so the reason did not concern him, right?
I'm sorry, I
The
don't
reason,
understand the context of what you presented.
didn't you just say, albeit for whatever reason?
Based upon the conduct that I saw through the convictions, I would say yes, I was concerned about his conduct and the convictions and the behaviors that he exhibited during those. So,
And then you ended that with, albeit for whatever reason, yes?
I guess I do.
Yeah. So in other words, the reason for it didn't matter to you as long as you observed this course of conduct, right?
Are you saying the individual acts? Are you asking me if the individual acts and the reasons for why he committed those?
Well,
Was I concerned about those? Is that your question?
Here's the question. You said albeit for whatever reason. What do you mean by that?
I guess I would affirm that by saying that regardless of why he did them, whether they're for political protest or some other protest, the acts that he carried out and the convictions that followed based upon behaviors, that's what I would say, albeit for whatever reason.
Right, so if it was for a political purpose, it didn't matter to you.
No, it doesn't concern me.
Thank you. No further questions.
Anything else? Okay, would you excused?
Thank you.
Yes.
Thank you. Anything else?
I may call the Sergeant Short to the stand briefly. I hadn't planned on it, but I'd just like to ask a couple of quick questions. Please raise your right hand and swear or affirm that the testimony is about to give this matter is the truth of the detained and penalty of perjury.
David.
David, please have a seat. If you could state your full name and spell your last name, record.
My name's Jason Short, S-H-O-R-T.
And how are you employed, sir?
I'm a sergeant, currently assigned as the prosecutor for the Keene Police Department.
And for how long have you worked as a police officer with the Keene Police Department?
It's almost 16 years.
And you're familiar with Mr. Horton?
Yes.
And you were in the courtroom this morning during the proceedings concerning his petition for a pistol permit?
I was here to observe it, yes.
Okay. And in the course of the proceedings, did you observe Mr. Horton himself in reaction to testimony by Detective Joel Chittister?
Yes.
And could you describe to the court Mr. Horton's reactions?
He seemed to be laughing and communicating.
Attention, irrelevant, Judge.
I think it's absolutely relevant. It shows how serious Mr. Horton is taking these proceedings.
Well, let me put it this way. I can say that I've noticed his behavior in court, and I'll ask speculated to what extent I should take that into consideration, but otherwise I don't think it's relevant as far as this witness is concerned.
Okay, I wasn't sure that the court could observe it because the court's been taking notes, but I did want to bring it to the court's attention. I thought I needed a witness to do so. Sergeant Short, you heard Detective Chivister testify concerning an arrest that you made of Mr. Horton concerning a drug charge, is that right?
Correct.
And did Detective Chivister summarize the facts concerning that arrest accurately in your mind?
Objection hearsay.
This witness,
Oh,
go ahead.
Yeah, it was accurate to whatever the report is.
Okay, thank you. Thank you, brother.
counsel.
No further questions.
Okay, thank you. All right, that's your case?
Yes,
Submitted?
and I would just make one more remark. I did, it
Is
concerns,
this evidence or is
it
this?
concerns Mr. Horton's evidence that has already been ruled concerning the
Oh, they've got their case to put on.
I understand that the court already did.
I don't know if there's going to have any testimony from the witness stand. Do you have any? Let's do it in order here.
Okay.
I think.
It concerns the CD that the court indicated it would take.
All right, we're not there. I don't think we're there yet, necessarily. So, unless I'm wrong.
Yes, we called Derrick. Yes.
I would ask that you be sworn in.
Do you swear or affirm anything you say will be the truth?
I affirm I will tell the truth.
Okay. You state your full name and address.
Yes, my full name is Derrick Joseph Horton. I also use the surname Freeman, and I live at 73 Leverett Street, Keene, New Hampshire, 03431.
And you heard the testimony of state's witnesses, correct?
Yes.
And there was a litany of offenses that were placed in the record that allegedly were committed by you, correct?
Correct.
Can you tell the court why you have that record? Why is that?
I have a criminal record here in Keene because I'm a political activist, and I aim to change the politics of the environment through my peaceful actions.
And what is that called? What is that political technique? Is there some name for that?
Yes, I call it civil disobedience. Others call it peaceful non-compliance. I'm inspired by people like Gandhi and Martin Luther King who did the same.
And in addition to your, well, what is your political activism then in terms of civil disobedience for? Why do you do this?
The reason I engage in peaceful non-compliance or civil disobedience is because I want to produce a peaceful world, and I want to live in a world where people are free to follow their conscience, free to do whatever they want so long as it's peaceful and they're not infringing on the rights of others.
So tell me, what issues are you concerned with that lead to these arrests? What issues? Tell me.
One of the things that concerns me the most is that peaceful pot smokers continue to be put behind bars. I think that's a travesty in 2014 that we know that marijuana is not a harmful substance, yet people who are peaceful, who have no other crime other than something like possession, would be put behind bars, as I was. And I illustrated that point by possessing marijuana openly. And
so you referring, what did your arrest regarding that?
Yes, during a what I call give peace a chance arrest. I made a big show of openly possessing marijuana in Keene Central Square, and it was clearly a political purpose.
Did you use marijuana then?
No.
And was there any, how many people were there?
I would estimate there were about 30 or 40 individuals there participating in the protest. There were also about 10 police officers on the scene. Also, watching the protest.
Now, you've been involved in other events.
Yes.
What other events have you promoted?
I started an event called Free Speech Friday that took place in Keene Central Square, where I would bring an amplifier and a microphone to the gazebo and give anyone the opportunity to redress their grievances, talk about solving community problems, and that was shut down by the Keene Police, unfortunately. And later, I held a dance party in the same location, and for the purposes of building community, again, in a peaceful way. And
what was the name of that dance party?
That was called the Live Free or Dance Party, and we had them on a pretty regular basis until the Keene Police finally destroyed my property, arrested me.
And what were you arrested for?
That day I was arrested for obstructing government administration and resisting arrest. Now that's an interesting one, and I want to clarify because there was some testimony given earlier by one of the earlier witnesses that the owner of the equipment stepped forward. Well, that's not true because the owner of the equipment is Ian Freeman. He's seated behind us in the audience. He was in jail at the time, and so I was the proper owner of the equipment. Unfortunately, I didn't get those charges. That would have been a much better way to fight it in court. But I wasn't able to bring up that evidence that this property belonged to me. And what I believe I was doing was protecting my property from being stolen, which is essentially what happened. That property was returned to its rightful owner, Ian Freeman, so there's no contesting my version of the events here. Judge Burke also knows this. So, now, other than free speech and marijuana, are there other causes that you've been arrested for or related to? Yes, video recording is one of the most important things to me. I believe a person has a right to record, especially government officials, in the course of their duties, and so I was arrested for recording inside the courthouse. I was also arrested for recording outside the courthouse. Now, one of those charges that was brought up against me for recording outside of the courthouse, I believe the date was February 27th, it was listed, that was dropped for the other people who were arrested that day because the charge was found unconstitutional. You can't ban someone from access to the court. But of course I was. And I was arrested for recording right on the sidewalk. Now, other people who took those charges on and said, hey, I'm not guilty, I'm going to take this to court, those were thrown out because it was unconstitutional. But me, I was facing too many charges at the time and pled no. I didn't have the time or the energy or the money to fight it. Okay. Now, you've applied for your license to carry in this town, right? And that's why we're here today. Correct. Because that was denied. Right? Correct. And what were the reasons you gave for wanting a license to carry? All lawful purposes. And including in that is self-defense, right? Absolutely. And did you have any, is there any aspects about yourself that might make you more vulnerable than others? I'm a gay man. I dress lavishly so people notice me. And that sometimes gains me unwanted attention. I've been harassed downtown in Keene Central Square and surrounding areas just for being gay and for dressing the way I do. Had my property swiped at, and all of these videos are available online. And in fact, I was assaulted just months ago, less than a block from this very courthouse, right here on this property. On the sidewalk by two individuals who were attacking me, I believe, because I'm gay. And they were brought on charges of assault and were convicted here. So that's all on the record. Can you take, if I may see exhibit 3?
Should be in front of the witness.
Thank you.
2011, charges of obstruction, resisting town ordinance, and resisting. Paul, what happened?
Yes.
Is that the offense date?
I believe it says that is the offense date from.
That is.
Yes, September 9th.
I remember it well. It was a
Right.
Friday night. We were having dance parties every Friday night in Keene Central Square gazebo. It was no problem. It was a great time. Lots of community members came out. We didn't have any complaints about noise until the police showed up. Now there was no lights or music on at the time that the police arrived, as reported in witness and officer testimony in my trial. And when the police came, they said, "We're fine, we just want the lights and music off and we'll go." Well, that was confusing to me because the lights and the music were off and they weren't gone. They instead insisted on staying and taking the property, the amplifier that I was holding, and I consider that to be theft. So I held on to the property, never swung any fists or got in a rage or any sort of anything like that, just held on to my property and was thrown to the ground. I was later handcuffed and walked over to the police cruiser. No struggle there. And when I was standing next to the police car, I said to Michael Kopcha, who was the officer arresting me, "I don't want to get in the car," expressing my desire to remain free rather than assist in my kidnapping. I repeated, "I don't want to get in the car," and he said, "You have to get in the car or I'm going to pepper spray you." And that's what he did. But it was purely verbal refusal. There was no physical refusal to obey. Of course, as soon as he put his hands on me to push me in the car, there was no force or pushback or anything. It just fell right in.
Have you ever been charged with assault of any type?
No assaults ever alleged.
Bring your attention to February 27, 2012, which was the arrest, resisting arrest charge.
Yeah.
I'll tell the court about that. The incident of 2012.
Yeah, that was amazing. So on February 27th, a photographer from the website Carlos Miller from photographyisnotacrime.com was in town in Keene to cover the courts here and their resistance to openness of recording and openness of cameras. He, of course, like I do, believes that government officials, when they're working for the public, everything that they do ought to be public. And so he wanted to go in and challenge the court's decision that a person can't record inside. Now, I knew I was already facing some charges, so I said, "This is great. I'm going to film from outside. I'll be the safety shot. I'll be at a distance, and if anything happens inside, people get arrested, at least I'm safe. I'll be able to get the footage and get it online and tell people what happened." Well, to my surprise, the bailiffs from the court came from inside the courthouse at Superior Court just next door and walked outside onto the sidewalk and began chasing me, saying, "Derrick, come here." Now at this point, I don't know if I'm under arrest or they're just saying hi or what. But I know that I don't want to have a conversation with them. I don't want to have anything to do with them. They don't look friendly. They have guns. And it looks like they are out to do me some harm. So I ran. And later, I was arrested while walking to my car. Unfortunately, no video of that exists, to my knowledge, because the video cut out. But that's what happened. Unfortunately, that arrest, I wanted to bring it to court and challenge it, because it's clearly unconstitutional to arrest someone for video recording out on the sidewalk of, you know, a public courthouse. The other people who did take that to court were victorious. It was found that that order was unconstitutional. You can't just bar someone from a courthouse. But I pled guilty, again, having too many charges on my plate at the time. I just couldn't deal with that, so I pled guilty to that.
During the time that you dealt with all these charges that have been placed on the record, did you ever have an attorney representing you through any of these?
No, I always operated pro se. I didn't have the money for an attorney at the time, and you know, I was pretty lost in the legal system. It's like being thrown into a professional baseball league. You're up to bat, and here you are playing with the pros, and I don't even know the rules.
Bring your attention to March 30th, 2012, and incidents of that day where that day.
Can you repeat the day?
It is March 30, 2012, alleging resisting and having notice of a valid court order with a bail order issued, alleging criminal contempt, and operating in charge of a vehicle, a bicycle.
Oh yes, that vehicle.
An issue, etc. What happened there? What was that all about?
So I was biking to the grocery store and went in the direction of the house, realizing at my home at the time, which was the other side of the duplex that I currently live on, and was going to pick up some more money on the way to the store. When a police cruiser comes by me and I'm like, well, let me get out of the way. I go to the side, and then it sort of stops and goes to the other direction of the street, like on the wrong side of the street, like in the direction of traffic. I'm like, what the heck is going on here? Let me get out of this. I move to the other side and pass along towards my house. And then Fenton Moore drives up beside me. I recognize him, I know who Fenton is. And he's like pointing and yelling, and he's got his sirens on, and I'm like, what? I can't hear him, I can't make out what he's saying at all. Obviously with the sirens on, I can't hear his voice, can't hear what he's saying. And he's just pointing, it looks like a crazy man, to be honest. And so I'm like, I don't like this, I don't feel safe, I want to go to safety, I'm going to my home. And I'm only about maybe 50 or 100 feet to my home at this point, so I'm like, all right, we get to somewhere safe. But Fenton Moore thought that the right thing to do, apparently, was to open his car door, drive up beside me, and smack me with it while I'm on my bicycle. This makes me lose control of my bicycle. He opens his car door again to do the same thing, and I swerve a bit, but so as not to injure myself as I fall, I coast along, and then he comes and puts a asp, or the baton from his belt, into my spokes, ejecting me from the bicycle as it suddenly stops. He then tackles me to the ground of a neighbor's yard, holds me down, gets on top of me with his legs spread, so I'm prone, sort of like a rape.
Counsel, I'm going to make sure guest decline not to inject his own editorial.
Well, his penis was touching my ass.
Objection, Your Honor. And
Tell your client is not helping his cause here today.
I just want to be clear where the genitalia was at the time of this.
That's 3 times now. I'll take a recess and you can talk to your client about the nature of his testimony and the coarseness of it. Or we can continue here. It's not helping his cause.
May I speak, my client?
Certainly.
Recess.
Recess.
careful with reading lips. It's all right. Oh, I heard about that. Monumental.
What's the session?
I have a seat. Okay, we're talking about the incident from March 30th, 2012, isn't it?
Yes, thank you. Mr. Horton, in terms of your political activity, did that incident ever get talked about by you or mentioned?
Yes, absolutely.
How did that happen?
Well, I wrote several reports about it immediately. I wrote reports from jail while still being detained. And then after being released, published those to a website, copblock.org. I also published them to my own website, derrickj.me. And I also host a radio show called Cop Block Radio where I talk about that.
Mr. Relevance.
Laying the foundation for the political use, etc., exposure of that incident that he had previously tested.
Unless there were repercussions against the defendant, and this is post the incident, correct? He's saying that he posted information or articles based on what happened.
Right.
Which he has every right to do.
Right.
But as opposed to some of the other convictions you talked about for the Central Square incident, which he was engaged in political activity in your opinion.
Correct.
This is a response to something as opposed to being actively involved in something. So what's the relevance to that?
Well, I think a political activist can be political both in preemptive or post or pre. I mean, politics is politics.
No, I see.
And he's
absolutely can do that. But I guess the issue is whether it's relevant what he did in response to this.
Well, his explanation of what occurred to him involves a sexual attack by an officer that he alleged and talked about. It would be a sexual assault that he alleged. He said rape. He said.
You're an attorney in this state, and you're alleging that your client was sexually assaulted by a police officer. Is that the allegation you're putting on the record here today?
That's what he was testifying.
Is that what you're putting on the record here today? Is that what you're asking to put on the record here today?
We can explore that further.
No, is that what you're asking to put on the record?
No, I'm talking about what my client was. I want to hear the rest of the story, but he was cut off.
I don't.
Okay. Well, then.
That's it.
Then.
That's it. You can appeal that decision. That's it.
I would ask that that objection be noted
as
well.
It's not relevant. That's the grounds for the objection. That's the grounds for the rule.
Have you been targeted by the police?
I believe I have, yes.
You can answer that question.
I think one of the examples I could give was that incident. I had already been served the paperwork Finmore was supposedly giving me. He knew that. It came over the radio while he was on duty, and that's on the record.
Objection calls for speculation. That is absolutely not on the record.
Oh, it'll be on the movie.
Your objection is sustained. Your response is stricken from the record.
Now, in regards to all of this political activity, you then use video. How do you use it?
So I use video as my tool of accountability. I believe that it creates an objective record that no one can debate what happened in a video, as long as it hasn't been edited. And So I publicize these videos on my websites and on other sites to make sure to expose police officers who abuse their authority and aren't held accountable by the system. So I use video to hold everyone, myself and others, accountable, and that includes government officials.
How are your videos distributed?
Well, I recently produced a full-length feature film called Derrick J's Victimless Crime Spree, which details some of my history here in Keene and some of the arrests for political activism that I've engaged in. That was released on DVD. It's available on Amazon at order.victimlesscrimespree.com.
I can just show you.
Counsel, did you talk to your client about, I mean, this is gratuitous information here. I just want to ask, all this information is not moving the ball one way or the other.
All I was doing
I'm selling this video.
was just laying the foundation for this video, and I was going to give it.
You don't need a foundation. I've already told them to listen to it.
Okay, then we don't need it.
And just
I'm watching.
That's all.
briefly, in regards to that video, since now it's being discussed, I'm going to note that Attorney Nappen has objected to the state's evidence coming in on hearsay grounds, which in the state's position, it falls clearly within the exceptions of the hearsay rule. However, this video absolutely does not fall within any of those exceptions, yet he is asking the court to consider the video. So I'm going to note for the record that he's asking for relief from the court on hearsay grounds when the state's evidence is concerned, but he's ready to submit this hearsay to the court.
And in response to that, I have a right to object to anything the state does. It's hearsay. The state has a right to object to mine. That's how we do it. However, in this case, with this DVD, we were going to play it in court and have my client, lay a foundation, etc., and talk about what's filmed. And instead of any of that, Your Honor, which we do not object to at all, was willing to take it and view it at a separate time in your consideration, and that's why it's not being entered or anything like that. And we're just going to.
Well, the court is certainly aware that the introduction of the video is going to be a mixed bag of information directly pertaining to the case. Likely some information that was probably not going to be relevant to the case. You raised the hearsay question, and maybe it's going to be up to the court to sift through that, decide what's going to be acceptable, well taken into consideration, and what I won't, and that'll be evident for the ruling.
I understand the court's ruling. I would just reiterate the state's objections not only in hearsay grounds, but relevance. It's unsworn testimony.
Well, without, I don't want the video played. It's not going to be played in court. I understand that there are some issues that are going to have to be unknotted by me when I go through it. You have to leave it to me to do that. That's all.
That's just renewing the state's objection.
I understand.
Thank you. Okay, so all these activities that have been put forward here, what was your motivation? What?
Throughout all of the activities that I've engaged in here in New Hampshire, it's part of achieving liberty in my lifetime, and I realize that's a broad way to put it, so I'll explain. The motto of live free or die from New Hampshire is what attracted me to move here. Death is not the worst of all evils. And where I was living in Philadelphia, I was feeling unfree, and I sought more freedom, so I moved to a place that had more freedom, voting with my feet. But when I came here, I realized there are still some issues of freedom that suffer. For example, marijuana freedoms and the right to record. And so my goal in engaging in this political activism was to free people from the constraints of the government regarding their ability to peacefully record government interactions and to peacefully engage in using their bodies like they own them.
No further questions. Thank you.
Thank you. Counsel?
Yes, thank you. You talked about the fact that you record people on a regular basis, is that right?
I record most of my life, yes.
And is it common in that practice for people to get upset with you when you're recording them?
No, that's uncommon.
It's not common for people to ask you to stop recording them.
More commonly than not, it is not a problem. So it would be unusual for someone to have a problem with me recording. It happens.
And you had referenced an incident where you were assaulted, is that right, earlier this year?
I was recently assaulted on this property right outside.
And you mentioned on direct that they were convicted, is that right?
It's my understanding that each of 2 individuals charged with assault were convicted.
Are you aware that they actually were not convicted?
No.
So you testified falsely? Correct?
Objection.
No, it's not sustained. He testified to what his understanding was.
And you had indicated that that assault happened as a result of your political activism, is that right?
No, I don't think that.
Oh, I'm sorry, I strike that. Those reactions by the persons that assaulted you were based on you being gay. That's what you testified to, correct?
I can't really speculate as to why they didn't give a reason. They came up and attacked my camera. Before that assault, the same individual had called me some names for being gay and had drawn attention to some of the clothing that I was wearing. So yes, I believe it is motivated in that way.
Okay. Isn't it true that those people were upset with you that because you were recording them, specifically a child, that's the reason they were upset? Isn't that true?
That may be. I can't read their minds.
Isn't that what they were? Weren't they asking you to stop recording them?
Yes.
And you didn't, did you?
I'm under no obligation to, so no, I did not.
And they didn't make any reference to you being gay. They simply asked you to stop recording them, correct?
I would have to watch the video for a reminder. Do you have it available?
So you don't remember?
It's on video. I'd love to see it.
What do you remember? I'm asking you what you remember about that. With respect to comments about you being gay versus comments about...
The comments were nice shorts, and they were pink, and they were short shorts. And the other comment was...
Actually, I have a Charlie question here. Are you're affiliated with a group of people, mostly the group of people that reside with you at Leonardstown, is that right? Also political activists?
Can you be more specific?
Sure. You are affiliated with a large group who share your beliefs concerning political activism, is that right?
What group are you referring to?
Do you call yourselves the Free Keene group or the Free Staters? Is that familiar to you?
I blog at a website called freekeene.com. In that sense, I am a part of a group of bloggers who are journalists at a website, yes.
And is Derrick J one of those people?
Objection.
Well, I don't know. Why is that relevant?
I think it's relevant. I'm going to ask if he's familiar with a recent statement Derrick J made about being an anarchist. I think it's relevant to whether Mr.
You can ask him if he's an anarchist, but I don't really care what Darren Dean thinks.
Are you an anarchist?
I plead the fifth on that.
Can't plead the fifth on that.
Why?
That's not a criminal issue. Asking you a political question.
Can you define anarchist?
An anarchist is someone who rebels against any authority, or uses violent means to overthrow established order.
No, that does not apply to me. That definition is not me.
Which part of the definition? The first part or the second part?
Can you repeat each?
Are you someone who rebels against any authority?
No.
Are you someone who uses violent means to overthrow established order?
No.
On the application, you had indicated that you're not an unlawful user of controlled drugs. Is that correct?
That's correct.
Do you use marijuana?
No.
Did you use marijuana back in 2012?
No.
You're aware that you pled guilty to possessing a controlled drug, specifically marijuana, correct?
Yes.
You talked about that incident. Isn't it true that you took a substantial step to use that marijuana? Isn't it true that you took a substantial step? You had it in your hands, you talked about using it, and you were about to light it up. Do you remember that?
I remember what you're talking about. As part of a political protest, I possessed marijuana. I admit to that.
If Sergeant Shorten hadn't stopped you, would you abuse it?
No.
Continue. Continue, State's Exhibit 3.
Thank you.
You're familiar with all those convictions that Detective Chister testified to earlier, correct?
I think so, except for one that was mentioned about Laconia. I don't know anything about that one.
Okay. But with regards to the convictions in this court outlined in that packet that you're holding, are those all true? You've been convicted of all of those offenses that Detective Chister testified to and that are in that packet?
It's quite a hefty packet. I'll need just a moment to review it. Okay, I've reviewed it, and could you repeat your question for me, please?
Are those all true and accurate convictions?
I don't know and I'm not trying to be picky, but I don't know the definition of conviction, and if could you help clarify, please?
Did you either plead no lower guilty to those offenses, or were you found guilty by this court after trial and after a no low plea?
Yes, I was either found guilty or pled nolo to each of these charges.
Okay. After all of those incidents occurred, did you move away from Keene for a while?
Yes.
Where did you go?
It's actually relevant.
I think it's relevant because he moved away from the area for a while.
Unless you have testimony or evidence to the extent that while he moved away, there was something that would impact his suitability for a permit. I don't know what, he could have moved away and just had a job and hurry up and come home.
I think it's relevant. A lot of his political activism occurs in Keene. All of his criminal convictions, a lot of them would stem from behaviors with this political group. I think it's relevant to show he's back in Keene. He's susceptible to this sort of behavior.
I guess the objection was to where he went and what he did.
Okay, I guess so. Yeah,
you can argue that he was gone for a while, but unless you have evidence that he was misbehaving in some way, I don't know if it's relevant.
May I ask how long away he's been away from Keene for?
Yeah.
What approximate dates did you leave Keene and come back?
I approximately left Keene in September of 2012 after a sentence in the House of Corrections. And I returned in this year of exactly remember the month, June. I'm pretty sure of that. Yeah, I think that's right.
Excuse me, I think just correct me on the ruling. I suppose this is not a criminal case. You can ask where he was and what he was doing to the extent that if he wants to admit or deny that there was any misbehavior or anything during that period of time that you weren't able to uncover, you suppose you can ask him that.
While you were away from Keene, were you arrested for any offenses by any police department?
No.
And were you in one particular spot, or did you move around the country?
I lived in one spot.
And where was that?
In Philadelphia.
And would you agree that you could still carry a firearm openly?
It's my understanding, according to the law, that in New Hampshire I am permitted, I have the right to openly carry a firearm.
So you can still defend yourself if need be by carrying an open weapon, correct?
That would be my right.
Okay, any redirect? Okay, thank you. You sit down, thank you. Any other witnesses?
No further witnesses.
Okay.
I'll just make a closing statement.
Okay.
And I would also, if I may give this to Your Honor.
Yes, I'm just going to stick around because I just want to make sure it's going to work.
Okay.
My computer before we go. This will take a minute.
Sure.
It's been the case and sometimes they don't work. Go ahead.
Thank you, Your Honor. Well, we have an application here for a carry license. It's been denied. It's been denied based on allegation of misdemeanor level criminal behavior. There's no felony. There's nothing that bars him from possession of firearms. As stated by the officer who reviewed all these records, he's allowed to possess firearms and he's not a felon, and that's clear. The question here then is whether a carry license can be issued, and here the chief denied the license based solely, as he explained, based solely upon his record that he reviewed as a, quote, course of conduct without any consideration as to why this record exists. And I put forward today, Your Honor, that that cannot be ignored. Cannot be. It is unrebutted that Mr. Horton is a political activist. It is unrebutted that all of these activities conform to his philosophy of his First Amendment right to communicate accordingly and following in the footsteps of many other political activists that utilize nonviolent civil disobedience. This is a classic technique. It's been proven. And he is following in those footsteps, trying to get, in his political belief, what is more liberty for New Hampshire. There is no record of any type of assaults, whether civil assault or aggravated, no assaults there at all. And he's being denied based on his misdemeanor record of politics. And that's what this is. New Hampshire's a political state. And that's what he's engaged in. Nothing there makes him a danger. Nothing. Doesn't make him a danger. Just doesn't. But what you see here is a chief making a denial based on a, quote, course of conduct without any other consideration as to why that took place. And I submit that that has to take place, that consideration has to take place under our own case law. Because even a felon can have a firearm under Kozersky versus Steer because it's not an automatic bar. What does that mean it's not an automatic bar? That's the court saying that. What it means is you got to look at the whole picture, the basis, what type of person he is. What are we dealing with here? We're dealing with an individual who's an activist, who is someone who is not inclined to violence. As a matter of fact, it's testified to, his radio show is about peace, he's about freedom, he's about nonviolent act. The state asked him specific questions about any type of belief in violence, adamantly denied it. It is not his activism for violence. He opposes it. It's not about violence, it's the opposite. It's about people's freedom and about their liberty and to remain unmolested in that pursuit. And that is what he's about. That's what that record represents. He should not be denied his Second Amendment rights because of his exercise of his First Amendment rights. And as a gay man, he has certain interests here that go beyond those that do not have that sexual preference, that create issues for him. He has a right to defend himself, to have that license, to not be denied his ability to carry under the Second Amendment because of his exercise of political speech, First Amendment activities, videoing, and these things that took place in this court. And here, I think the court sees what he's about. This isn't some career criminal that just commits misdemeanor crimes so that he can be a menace to the public. He has a bona fide, legitimate basis for why he does what he does. It does not make him a danger. That is the key. It does not make him that. It's the opposite. He's not a dangerous person. He is a political person. He's not a dangerous person. This is the essence of what makes this case really so interesting. And he has produced videos, put it online, blogged about it, and has testified all of that accordingly. There's no doubt what his motivation is. It's politics. He should not be denied his license because of politics. And I would respectfully request that his appeal be granted. Thank you, Your Honor.
Counsel, you mentioned case law. You mentioned one case. Are there any other cases you want me to refer to? Or?
Well, Deserski versus Steer would be a key. And, I mean, there's a general body of that I'm sure Your Honor will rely upon, but I would just, for my purposes,
I don't know if there were specific cases you wanted me to look up.
That would be specific. Thank you.
The state respectfully requests that the court uphold Chief Mueller's decision to deny Mr. Horton a pistol permit application. Because he's not a suitable person, I think the court heard overwhelming evidence today as to just why he is not a suitable person, including Mr. Horton's own behavior in the courtroom, specifically his testimony and his laughter and his smiles in regards to testimony. I think that shows his true character, his lack of maturity, his lack of maturity. It shows that he is absolutely immature and he's not suitable for those reasons. And also, because of his numerous police contacts that has resulted in numerous convictions from offenses on multiple different dates that the court can refer on its own, specifically 4 different offense dates resulted in convictions for 3 counts of resisting arrest, 1 count of obstructing the report of a crime or injury, obstructing government administration, 1 count for criminal trespass, and 2 counts for contempt. Those convictions show that he's repeatedly disregarded not only lawful orders of this court, but lawful orders made by police officers to either stay where he is so they can have interaction with him, or to comply with lawful orders of arrest. He's shown that he's resistant and violent to police officers. This is someone who should not be able to carry a concealed weapon. And I will draw the court's attention to a case that I cited in earlier pleadings, specifically Weiler, the chief of the Dover Police Department. The court specifically talked about public policy reasons why these statutes are in effect, and specifically held that someone's right to bear arms in self-defense is not impaired by requiring an individual to carry openly. Mr. Horton is permitted to do that, but he is not someone who should be carrying a concealed weapon. For all those reasons that the state cited, and I would ask the court to read that case because it goes into more detail about those public policy interests in play, and those are the reasons why Chief Mueller denied his pistol permit application, and he did so rightly.
A couple of points here. One, you mentioned before that the question is the court's made observations of your client here on other occasions. To what extent should I take into consideration, not take into consideration his demeanor and his attitude toward the proceedings here?
Well, Judge.
He's asking the court to rule in his favor.
Yes.
And should I take into consideration the fact that his conduct seems to fly in the face of that?
I don't. First of all, his conduct on the stand was.
I'm not talking about that. I mean, he wanted to say some things I didn't think were appropriate. I thought they were gratuitous, coarse, but that's not going to be held against him.
Okay.
The question is whether or not I should take into consideration his attitude toward these proceedings.
So I think without further investigation, where the state had the ability to ask him anything they wanted to about what was observed here, without any of that taking place when the state had a full opportunity to explore that, I don't think anything should be noted as to what he was doing sitting behind this desk, and that had full opportunity for being explored. on the stand under oath. So I would say, no, Your Honor, should not be considered.
I specifically didn't ask Mr. Horton because I didn't expect an honest response. I think the court observed Mr. Horton's behavior in the courtroom. Sergeant Short testified to that briefly. I don't think I needed to ask Mr. Horton about it specifically. I didn't, for the reason I just stated.
The other thing is there's a reference to a decision about the filming in the courtroom or the courthouse. And I've issued some rulings related to the other courthouse, but was that a decision that this court made? Was that a decision that the Superior Court made? Because I made a decision with respect to that it was founded on constitutional grounds in favor of the defendants on a trespass case in that building. But that didn't sound like my case.
He said, Your Honor, my case is Superior Court decision.
Yeah,
That had nothing to do with that case, correct?
No, Mr. Horton was trespassing at that building unless he got advanced permission. I actually don't.
Well, I did do a ruling there, but if I remember, there were 3 defendants who were who challenged that,
right?
And I issued a ruling in their favor in that case. But I'm trying to make sure I understand. Mr. Horton was not part of that group, that he had pled guilty to that charge before that. I just want to make sure I'm not mixing up decisions here.
I can't give the court.
I'll be able to figure it out.
But I would ask the court to consider the resisting arrest conviction also from that date. I think that's sort of
I know what you're asking me to consider. I just want to make sure
right.
I'm not pulling
Sure.
or referring to the wrong cases. I think those are my questions for now. Can I just have the video, please?
Yes, thank you.
Just give me a minute and I'll let you go. All right, thank you. I'll take it under advisement.
Thank you, Your Honor.
Court's in recess.
Your Honor, should I just wait here and review this?
I'm going to do it right now.
Thank you, thank you.
We'd like to invite you to visit freekeene.com. Freekeene.com features audio, video, and blogs chronicling the transition to a voluntary society. Freekeene.com also has comments and discussion forums so you can be heard. Freekeene.com.
I should be in Keene, New Hampshire with the Free Staters.